Hi everyone, welcome to our YouTube channel where we talk about topics under the different subjects of the BS in Criminology curriculum. So we're going to continue with our Criminal Law Book 1 and Book 2 series, specifically Book 2. And I believe we are now on the second title for book 2, so that is topic number 7. So it's all about crimes against fundamental laws of the state. For example of those is arbitrary detention, expulsion, violation of domicile, search warrant related crimes, etc. So basically, just for a short quick introduction background regarding the particular topic. So the fundamental laws of the state is basically talking about the different rights offered to us by the Constitution itself, particularly those which we can see in Article 3, which is the Bill of Rights. So, with the exception of rights to life and property, which has their own specific titles. So, some of the rights here mentioned in Bill of Rights or Article 3 is right to religion, right to freedom, right to peaceful assembly, right to communication. So in this particular title, we are going to talk about those particular rights. Okay? So if everyone is ready, umpisahan na natin tong title 2, Crimes Against Fundamental Laws of the State. Okay? So the first right or the first crime that we are going to talk about here is arbitrary detention, and that is located in Article 124. That is the very first fundamental laws of the state crimes that we are going to tackle for this evening. So, in the crime of arbitrary detention, our offender is a public officer or employee. Later on, we will learn what does a public officer or employee mean. Okay, but we have a special consideration for the offender here because when we talk about public officer or employee under arbitrary detention, those are the people which are vested with arresting power. Dapat meron silang kapangyarihan to make an arrest. Okay, so those are the people who are our offenders for the crime of arbitrary detention. So what are the elements of arbitrary detention? Number one, that the offender detained a person. Okay, so that's under Article 124. Kailangan meron siyang ikunulong na tao. Okay, and the penalty for arbitrary detention will depend on the length of detention. Okay, depende sa haba ng detention nung pagkakakulong doon sa tao na wala namang ginagawang kasalanan ang magiging penalty ng arbitrary detention. And the detention, of course, is without legal grounds. When we say without legal grounds, wala dapat nagawang krimen. No crime was committed by the person detained, and at the same time, or the person detained is not insane. Hindi dapat siya siraulo. Okay? So basically, the offender here, which is a public officer or employee, detained a person, okay, and such offender have the arresting power, but the detention is without legal grounds. Walang sapat na dahilan or hindi naman sira ang ulo ng taong ikinulong. Okay? So, if we're going to compare arbitrary detention from illegal detention, there's a very thin line that separates the two crimes. Okay? So, as the offender, arbitrary detention, the offender here is a public officer vested with authority to detain a person. While on the other hand, when we are speaking about illegal detention, the offender here is a private individual. Okay, as the reason for detention in arbitrary detention, Article 124, the detention is without legal grounds. While on the other hand, for illegal detention, the detention is about the deprivation of liberty. Gusto mo lang talagang um, alisin siya ng karapatan niya sa kanyang kalayaan or gain as in the case of kidnap for ransom. Okay? So, in specific cases like for example, kidnap for ransom, ang rason mo kung bakit mo ikunulong yung tao is for the monetary value, the ransom itself. Okay? So, that's illegal detention. Specifically, what we call serious illegal detention. Okay? So, that is the difference between arbitrary detention and illegal detention. So, illegal detention, just to wrap it up, illegal detention is committed by a private individual while arbitrary detention is committed by a public officer with arresting power. And as to the reason, wala tayong sapat na dahilan for arbitrary detention. Again, walang ginagawang krimen or hindi naman sila siraulo yung taong ikinulong natin. While on the other hand, for illegal detention, the detention is basically about deprivation of liberty. Gusto lang natin, ayaw lang natin siya bigyan ng kalayaan o kaya naman, we are waiting for ransom in the case of kidnap for ransom. Okay, so that's arbitrary detention under Article 124. There's another form of arbitrary detention. This time, we call it delay in the delivery to proper judicial authority. Okay, so the offender for this crime, Article 125, delay in the delivery to proper judicial authority, is still a public officer or employee. And again, he or she is vested with authority to make arrest. Meron siyang kapangyarihan para magsagawa ng arrest. While on the other hand, just to make it different from Article 124, in Article 125, the offender here detained a person for some legal ground. Ibig sabihin, meron siyang dahilan. Okay? Meron siyang dahilan kung bakit niya ito inaresto, kung bakit niya ito ikinulong. Okay? At yung dahilan na yon is legal. Valid yung rason na yon. But the problem is that the offender failed to deliver the person to proper judicial authority. Okay? So that becomes the problem. Hindi niya i-deliver sa proper judicial authority within letter A, 12 hours for light penalties, 18 hours for correctional penalties, and 36 hours for afflictive penalties. Just to separate the three level or the three classification of penalties. So when we say light penalties, those are those crimes that has a 6 months maximum penalty. Okay? Pag 6 months pababa, then that is considered light penalty. While on the other hand, pag sinabi natin na correctional penalty, that is 6 months and 1 day to 6 years. While afflictive penalties are those crimes which has a penalty of 6 years and 1 day up until life imprisonment. Okay? So, depende sa haba ng pagkakakulong, depende sa penalty na meron yung krimen na ginawa yung tao. Because sabi nga natin, the detention is with some legal grounds. Okay? So, pag sumobra ka sa 36 hours for those crimes which has 6 years and 1 day up penalty, then you will be liable for delay in the delivery to proper judicial authority, provided that you are a public officer or employee with authority to make an arrest. So, ano ba yung ibig sabihin natin dito kapag sinabi natin na deliver such person to proper judicial authority? So, when we say deliver such person, that means that this phrase does not pertain to physical or bodily transfer. Hindi natin dito tinutuko yung talagang pag-deliver, yung physical na pag-deliver ng katawan to proper judicial authorities. Rather, this phrase pertains to filing of information or complaint. Okay? So, ang tinutukoy pala natin kapag sinasabi natin na deliver to proper judicial authority is sampahan ng kaso. So, that means that within 12 hours, 18 hours, or 36 hours, depending on the case, we must be able to file proper information or complaint to the person para hindi tayo maging liable ng delay in the delivery to proper judicial authorities. So, who is the proper judicial authority? That's the next question. So, when we say proper judicial authorities, that refers to the courts of law. For example, the municipal trial court, the regional trial court, the municipal trial court in cities, the municipal circuit trial court, the Sandigan Bayan, the Court of Appeals, and the Supreme Court, and not, take note of this, not the office of the prosecutor. Although the office of the prosecutor is considered a lawful authority, it is not considered a proper judicial authority because that is not a court. Okay? So, hindi sapat na nakapag-inquest lang tayo. I mean, hindi sapat na i-file natin sa Office of the Prosecutor yung kaso. Kailangan from the Office of the Prosecutor, nagawan ito ng information and it should be delivered, it should be submitted to the proper court. Because when we say proper judicial authorities, we are speaking here about courts of law. Okay, so take note, in conjunction with Rule 112, Section 7 of the Rules of Court, I'm speaking of this particular phrase here. It is required that the arrest made without warrant should undergo inquest proceeding. So that's a given, di ba? Na I believe we have discussed that even in the Philippine criminal justice system subject, that if there is an arrest made without a warrant, it should undergo an inquest proceeding. So the fact that a reglementary period 12-18-36, we are talking about the time depending on the penalty, is present in Article 125, denotes that the arrest made hereunder, though may be legal, was made without warrant of arrest. So ito palang arbitrary detention na to, Article 125 of the Revised Penal Code, Title 2, tumutukoy ito doon sa mga aresto, legal aresto, da ginawa ng walang warrant. Okay? So, kailangan dito ng inquest. So, as the application for warrant of arrest was based solely on probable cause and lodged exclusively to a judge, take note of that line, lodged exclusively to a judge. That means that the determination of the validity of the warrantless arrest should also be determined by a judge who is the representative of a court. Anong ibig sabihin nun? Generally, when we are making arrest, we need warrant of arrest, except for some situations where we can make an arrest even without a warrant. So, sino ba yung nagpipirma ng warrant of arrest? Di ba? Si judge, not the prosecutor. Si judge. So, ibig sabihin, kung meron man mag-determine ng probable cause in order to validate a warrantless arrest, hindi yon si prosecutor, si judge yon. Okay? Because the judge, not the prosecutor, is the representative of a court. So that's why siya yung proper judicial authority. Ibig sabihin, kapag tayo ay nag-file ng complaint sa Office of the Prosecutor, okay, even if hindi pa tayo umabot dun sa reglementary period na 12, 18, and 36 hours, then we may still be liable for delay in the delivery to proper judicial authority. Bakit? Kasi hindi pa siya nakarating kay judge. So, ibig sabihin, if a particular case needs to be filed from the Office of the Prosecutor still within the same time frame, okay, within the same time frame, kailangan makarating yan sa proper court. Hindi lang dapat siya mahinto doon sa Office of the Prosecutor para hindi ka maging liable for violation of Article 125, delay in the delivery to proper judicial authority. Okay? So that's Article 125, arbitrary detention, delay in the delivery to proper judicial authority. And on the other hand, the last form of arbitrary detention is Article 126, which is all about delaying release. Okay? Tungkol naman ito sa release. So what does it says? Ang offender natin dito is still a public officer or employee vested with power to detain a person. So basically, we're talking here about either police or members of the BJMP or members of the Bucor, whatever the case may be. All right? So as to the consideration, as to the elements, there should be a court order, or if not, a presidential pardon, or if not, a petition for the liberation of a detained person. Okay? So, meron na dapat court order, meron dapat presidential pardon, or even a petition for the liberation of a detained person. But, the offender here, without any good reason, delayed. Okay? Dinelay niya. Dinelay niya yung A, service of the notice of such order for the release of a prisoner. Okay? Meron ng order na palayain na yung tao pero dinelay mo yon. Imbis na in-execute mo yung order within the day that the order was received, pinaumagahan mo pa o kaya naman pinatagal mo pa bago mo siya release. Then that person will be liable for delaying release. Letter B, the performance of such judicial or executive order for the release of the prisoner in the case of pardon or amnesty. So there is a order from the president himself that the a particular prisoner is already pardoned or is already amnestied. So, anong nangyari dito? Hindi mo pinerform yung judicial or executive order na yon na dapat makalaya na siya. Or, letter C, the proceeding upon a petition for the release of a person detained. Okay? Yung proceeding para ma-release yung person upon a petition, dinelay mo yon. Okay? So, kapag nagkaroon ka ng delay, being a public officer or employee vested with the power to detain a person, on releasing the person by virtue of a notice, on releasing the person by virtue of a judicial or executive order, or releasing the person upon a proceeding, upon a petition, then you will be liable for delaying release. Okay? Yan. So the next crime after 126 is expulsion. So what is all about expulsion? So expulsion here is talking about Article 3, Section 6 Bill of Rights, which says that the liberty of abode and of changing the same within the limits prescribed by law should not be impaired, except upon a lawful order issued by the court. So this is basically talking about your right to choose your own home. 'Di ba? Yung karapatan mo na manirahan kung saan mo gustong tumira. Okay? Kasi pag sinabi natin na expulsion, you are expelled. Pinalayas ka. Okay? Hindi ka pinatira doon sa bahay or sa lugar na kung saan gusto mong tumira. All right. So who is the offender for the crime of expulsion? Public officer or employee. Again, the fundamental laws of the state, our offender here is almost all of the time a public officer or employee. And then the offender in the crime of expulsion, number one, expelled any person from the Philippines. Pinalayas mo ng Pilipinas nang wala kang sapat na dahilan. O kaya naman, number two, compelled a person to change residence. Pinalipat mo siya ng tirahan nang wala ka namang sapat na dahilan. That is illegal because that is violating Section 6, Article 3 of the Bill of Rights, your freedom of abode. Okay, so that's all about expulsion. The next crime is violation of domicile. So, just to give you an idea, when we say domicile, that is basically a place where you rest and you comfort yourself. Okay, so yan yung lugar kung saan ka nagpapahinga, kung saan ka nare-relax. Alright, so domicile. So when you violated that particular place, diba, that will constitute a violation of your Bill of Rights. Specifically, if I'm not mistaken, the freedom to unreasonable searches and seizure, right? The freedom to your own property. Okay, so that's a combination of that. So the offender here is still public officer or employee. So what are the elements of the crime of violation of domicile? Number one, offender is not authorized by any judicial order to enter the dwelling or to make searches therein. Walang authorization of under any judicial order na pasukin mo yung bahay. Okay, napasukin mo yung bahay kung saan ka magsasagawa ng search. When we say not authorized by judicial order, that basically means that you do not have search warrant. Okay, wala kang search warrant nung pumunta ka sa bahay kung saan ka magsi-search. And then, second element, number two, the offender committed any of the following act. Number one, enters the dwelling against the will of the owner. Ayaw kang papasukin, wala kang search warrant, pero pinilit mong pumasok. That's violation of domicile. Or, letter B, searches for papers or other effects without previous consent of such owner. Okay? Nakapasok ka for whatever reason, and then naghanap ka ng mga papel doon or ng other effects na hindi alam nung may-ari ng bahay. That's violation of domicile. Number three, refuses to leave such premises after having surreptitiously entered such dwelling and after having been requested to leave the same. When we say surreptitious entry, that means that your entry is without the knowledge and consent of the owner. Okay? Hindi ka naman pinayagan pumasok, pero pasikreto kang pumasok. At nung mahuli ka, hindi ka lumabas. Okay? So yun yung ibig sabihin ng letter C. Refuses to leave such premises. Pinapalabas ka na after pasikreto kang pumasok, pero hindi ka lumabas. Okay? Ayaw mong lumabas. Hindi ka sumunod doon sa request. Then that is a crime violation of domicile. So, when we have violation of domicile, meron tayo ditong tinatawag na qualifying circumstances. And when we say qualifying circumstances, that would generally aggravate. Mas papalalain ito yung penalty mo if done under the following circumstances. Number one, the offense was committed at night time. Gabi ka nung pumasok doon sa bahay ng pasikreto or nagpumilit kang pumasok na ayaw nung may-ari or naghanap ka ng mga papel or other effects without the previous consent nung may-ari or nung makapasok ka, pinapaalis ka pero ayaw mo umalis. Kapag gabi mo ginawa yon, then that would qualify the offense of violation of domicile. And number two, any papers or effects confiscated were not returned immediately after the search made by the offender. Kinuha mo, kinonfiscate mo yung mga papers or other effects and hindi mo yon ibinalik agad, whether or not day or night man yan. Okay? So, that will qualify or mas papataasin nun yung penalty mo for the crime of violation of domicile. So, ano ba yung constitutional basis natin na violation of domicile? That would be Article 3, Section 2 of the Bill of Rights, which is all about unreasonable searches and seizure. Alright, so that's violation of domicile. And then the next one is malicious search and abuse in service of search warrant. So who are the offenders here? Still, public officer or employee. So anong ginawa dito ni offender para masabi natin na crime? Malicious search and abuse in service of search warrant. So there is actually a search warrant in this particular crime. Okay? Meron ka ditong hawak na search warrant at meron ka ditong just cause. Okay? At meron ka ditong sapat na basehan para i-execute yung search warrant na yon. Only that, you exceeded the authority in serving the same or uses unnecessary severity in execution of a valid search warrant. So, ano ba mga example nito? So, di ba sa search warrant, diniscuss na natin yan during our Philippine Criminal Justice System subject that you can only search and you can only confiscate those items which are listed in the search warrant, except if those items were searched or were confiscated in plain view. So, kung hindi naman siya naka-plain view at wala naman siya doon sa listahan ng mga items to be confiscated under the search warrant, hindi mo dapat siya kunin. Diba? Pero pag kinuha mo yon, you exceeded your authority in serving the same or serving the search warrant, kumuha ka ng sobra na wala naman doon sa lista, hindi mo naman kinuha by virtue of the plain view doctrine, then you will be liable for violation of malicious search and abuse in the service of search warrant. Or if not, kung hindi naman yan, you employ unnecessary severity in the execution of a valid search warrant. So aside from the items to be listed on the search warrant, kung ano mga dapat mong kunin, naka-indicate din doon sa search warrant kung saan mo siya dapat kunin. Pero instead of searching on that particular location, pinilugog mo yung buong bahay. Pinagtatapon-tapon mo pa yung mga gamit-gamit doon. That's illegal. Okay? Malicious search na yon. And that is already an abuse in the service of search warrant. Because the act of searching the entire place, even though not mentioned in the search warrant, is already severe and is already unnecessary. Okay? Unnecessary severity in the execution of a valid search warrant. So if you committed those particular acts, naging sobra-sobra yung kinonfiscate mo or naging sobra-sobra yung pag-manner ng paghahanap mo, then you will be liable for the crime. Okay, next one. Searching domicile without witness. So it is also an understandable rule and it is also an established rule in the execution of a search warrant that if you are searching, okay, there should be the witness. Okay, there should be a witness. And that witness, as much as possible, should be the owner of the house. If not, kung wala naman yung may-ari, any relative na nandun sa bahay. If not, at least two witness from the locality, from the community where you are going to search. Now, if you did not secure any witness during a search, then you will be liable for this particular crime, searching domicile without witness. So who are the offenders here? Still, public officer or employee. In most cases, police officers. Okay, so what are the elements of the crime searching domicile without witness? Number one, the offender has a legally procured search warrant. So basically, meron kang search warrant. And the search warrant here is valid. Okay? And then you executed the search warrant. You search for the domicile, papers, or other belongings by a person. Okay? But the problem is that the owner or any member of the family or any two witness residing in the same locality are not present during the search. Walang nanood sa'yo habang ikaw ay nagsisearch. Okay. So, dahil ginawa mo yon, wala kang witness, you will be liable for the crime. Searching domicile without witness. Again, what do we mean by domicile? That is a place which a person considered his home. A place for rest and comfort. Okay, so that is searching domicile without witness. The next crime that we're going to talk about here is prohibition, interruption, and dissolution of peaceful meetings. Our Bill of Rights, if I'm not mistaken, that would be Section 4, or if not Section 5, is also giving us the right to form peaceful assembly. Okay? Pinapayagan tayo ng ating saligang batas na makipag-assemble sa ibang tao so long as that assembly is peaceful, because that is still part of our right to communication and right to peaceful assembly. Okay? So if you are going to prohibit or interrupt or dissolute, meaning buwagin mo yung peaceful meeting na yon, then you are actually violating the fundamental law of the state, which is right to peaceful assembly. So who are the offenders here? Public officer or employee. So what did the public or officer or employee do here? The offender performs any of the following act. Number one, prohibit, interrupt, or dissolve without legal ground, walang sapat na dahilan, a peaceful meeting. Okay? Or you hindered any person to join any lawful association or attending any of his meeting. So, kung ininterrupt mo yung meeting mismo, pinagbawalan mong mag-umpisa yung meeting, or dinisolve mo yung meeting na yon nang wala kang sapat na dahilan, then you will be liable for prohibition, interruption, and dissolution of peaceful meetings. Or kahit hindi mo yun ininterrupt, but meron kang pinigilan na tao na mag-attend sa lawful association, sa lawful assembly na yon, then you will be liable for the same crime. Okay, next up, interruption of religious worship. That is Article 132, and offending religious feelings, Article 133. So I basically just combined the two articles here in one simple explanation. Again, fundamental laws of the state that is given to us by our Bill of Rights, and another right which is given to us by the state itself, by the Constitution itself ng ating saligang batas, is the right to religion. Okay? Right to religion. Karapatan natin yun na pumili ng sarili natin na relihiyon. Ibig sabihin, kahit siguro mga magulang natin, hindi tayo pwedeng pagbawalan. Kung for example, gusto natin lumipat ng ibang relihiyon. Why? Because that is a right given to us by the state itself. Okay? So under Article 132 and under Article 133, these are the acts which interrupts or offend religious feelings. Okay, so who are the offenders here? Public officer or employee. So what are the elements for the crime of violating religious feelings? Under Article 132, there is a religious ceremony or manifestation which is about to take place, and the offender prevents or disturbs the same. Mag-uumpisa na yung misa, yung police biglang pumasok sa eksena. Sabi niya, ay hindi to pwede, bawal itong misang ito. Then that's a crime. That's interruption of religious worship. Kung hindi naman, Article 133, offending religious feelings, acts complained of were performed either in a place devoted to religious worship, and during celebration of any religious ceremony. And number two, acts of the offender notoriously offensive to the feelings of the faithful. Okay? Kung apektado mo, kung offensive masyado yung act na ginawa mo for the feelings of those members of the congregation, members of the particular religion, then you are actually committing a crime. Interruption of religious worship and offending religious feelings. All right, so that is the crime. All right, and that concludes Title 2 of Book 2 of Criminal Law, which is all about crimes against the fundamental laws of the state. Our next topic for this particular series will be about Title 3, Crimes Against Public Order. So basically, this is a very lengthy topic, Title 3. Medyo mahaba ito. So, hahatiin natin ito sa dalawang video. Okay? So much for that. Abangan na lang natin yan sa susunod natin na video instruction. For now, I have to say goodbye and salamat sa pakikinig. And of course, just stay put. Okay? Just stay put. Just try to subscribe and abangan natin yung mga susunod na video explanations. And I hope that I was able to help you understand better much easier itong title 2 ng ating Criminal Law Book 2 series. For now, I have to say goodbye and salamat na ulit, again, once again, as always, sa ating pakikinig. Bye-bye!